Thank you, everybody, for your patience. This is case number 2024-384-DM, John McKediak versus Lindsay McKediak. It is Friday, August 2nd, 2024 at 8:41 a.m. Attorney Ashley Smith is for the defendant.
Okay. This matter is set for today's date for basically a bench trial in this particular matter. I know Ms. Smith, you have just recently come into the case. Anything before we commence?
Yes, Your Honor. My client and I would request an adjournment of today's hearing due to myself just being retained and unfortunately not having a chance to catch up and properly prepare for the hearing, and also due to having conflicts.
Conflict? Oh, you mean for scheduling conflicts?
Yes, Your Honor, for today.
Okay. Mr. McKediak, any response to the request for an adjournment?
I mean, we've been dealing with this for months now, Your Honor. Didn't want a lawyer. She didn't want anything. I don't know why it needs to be prolonged any longer.
Yeah.
She told you in the last.
Okay. Well, I understand that, and obviously it has been, the case is 175 days old, so the court recognizes that. But by the same token, obviously, the defendant is entitled to representation, as you are, sir, and she has just recently had Ms. Smith retained, apparently. So the court is going to grant the motion for an adjournment. The court will set this matter for the next bench trial on August 23rd, 2024 at 8:30 a.m. So put that down on your calendars. It's August 23rd.
Thank you, Your Honor.
So it'll be basically, it'll be 3 weeks from today's date.
Are we setting a judge for half or a full day?
Doesn't matter. We'll set up for 8:30. Okay, you're free to go. Have a good day.
Thank you. Thank you, Your Honor. You too.
All right, thank you.
301481 Ariel Hodgson. Good afternoon, Ms. Klubish, Ariel, we have people. Ms. Hodgson, state your name. Today's date and time set for, well, at this point in time, it was set for a review. There's been some new allegations that have come forth. Mr. Smith, realizing the incredibly short amount of time that you would have a chance to take a look at these things, the court was not inclined to set it for a violation today, just so you know.
I've already looked at it. I had it a while ago. I had all the messages.
So there's new looking at it.
Those are just screenshots. I was aware that there was some screenshots. I'm ready to do it. I'll wait as long as you want. I don't think this is a violation. That's going to be my argument. I'm not disputing that anything was. I'm not disputing anything was said. I'm not disputing anything at all. I just don't think it's a violation. I'll call one witness, and he'll testify to what he told Alvin, and we'll make a decision. There's no more than I can stipulate to all of this stuff because it's a fact that it was said.
So just so I can walk through this. So it's my understanding that people are alleging at the time of sentencing, the court instructed Ms. Hodgson to not any direct or indirect contact with a number of people. And one in particular being last name.
Yes.
And the allegations from the people are that, to my understanding, I don't have screenshots, I don't have this information, but that from jail, she provided some direction to her husband to relay information to this individual, information that would generate a reaction such that would cause some type of issue or contact with Ms. Now, there are a number of layers to this, but as you can imagine, I've been at this a long time. I know individuals who try to get to people. I know that there's direct, and then there's very complicated and I guess well planned out ways to get to someone through others. Now, I don't know if that's what the people are ultimately alleging, that Ms. that Ms. Hodgson in the end used her husband and this Alvin individual to get to Ms. First. That seems to be what the allegation is, correct, Mr. Peskovich?
Yes, Your Honor, that is the crux of it, but also there were screenshots from the defendant's phone sent to Alvin Spencer on June 22nd, 2024 from the defendant's phone. That's the day the defendant got out of jail.
Okay, so now this is taking her husband out of the sort of out of the line of
That's the
this effort.
second piece to it.
Okay. All right, so.
And my one witness will justify that he's the one who sent these to Alvin, because Alvin broke up with this and was a witness, protected witness, because you put her on no contact. It's actually in a separate section than the actual complaints in the case. But I think it's pretty clear that.
I mean, I can pull up her sets.
Yeah, it's pretty clear.
I mean, it's pretty clear. There.
It's not a real issue. The only issue is this a violation in light of what Dan is going to say about what he did in respect to relaying information to a man who reached out to him after he broke up with him. Again, this is like Jersey Shore kind of stuff. It's silly, but it could be construed as a violation. I don't think it is a violation, based on what I know. And I think it will take you 10 minutes to discover that. And I'll stipulate to these items I've already had access to for a number of days. And this new stuff will come in. I have no problem with that, because in fact it was sent by my client's husband. And the question for the court will be, is this communication with the caveat that my client's husband said, by the way, do not relay any of this to at all? Is that a violation? Because that's what he said.
Mr. I guess the court will have to make that determination.
They had a full conversation with your probation officer. Dan did, I guess, in the last day or so. I mean, all of this. There's some.
That's part of in the workup for hearing worksheet. That's one of the allegations, as well as making an untruthful report to probation officer.
Well, I expected this.
I know you have an exam.
Yes.
So
Yeah, we're gonna go into the exam, so
I can take the whole afternoon.
it's gonna take the bulk of the afternoon. So I would invite you to have more conversations with Mr. Peskovich. I am here, I'll be here for a while. I have no problem managing this after the examination, or if there's some other specific date that's selected, it doesn't matter to me, but I would invite you, Mr. Peskovich, to have some additional conversations about this with Ms. Linke and see if we can make it as streamlined as possible. But for the defendant and the prosecutor and defense counsel on the Rye matter, we had adjourned this from another day, so we're going to start and continue this exam.
All right, so we'll stand by and then report back to you in break.
Yeah, I'll have my court officer and I'll Monica check in with you from time to time to get you updates. Okay.
Yeah, my plan, if we do something, is just stipulate all of it and make my arguments and call them.
Good, that's fine. Okay. All right, Cameron Rye, 2400194.
Good morning. Can you hear us?
Yes,
Okay, very good. And you are Joyce present, correct?
yes.
All right, welcome. This is case 23-3862 SD. Ms. Present is zooming in with us from the Antrim County Jail this morning with her attorney, Mr. Sheffalo, also on Zoom. And live in the courtroom with me is Ms. Ferrara Wilbur from the prosecutor's office. We're here for purposes of a video bench warrant arraignment. Mr. Sheffalo, have you had an opportunity to speak with Ms. Present about this bench warrant?
I have, Your Honor. I spoke with her yesterday while she was in the jail. She was able to conduct a call with me and discuss her situation.
Excellent. The last we spoke, the plan was for the probation department to schedule a probation plea and sentencing. And how would you like to proceed today?
Well, with his, we understand we can't do the plea today. I was hopeful that we could get that on the books as soon as possible. Your Honor, I think it's all going to merge together once we're in front of the judge with the plea and then the ultimate disposition by the court. So certainly I'd love for her to have a bond reinstated, but I don't know how that would even overlap with the previous case where she was asked to turn herself in. And if she was released, then is that going to delay us getting in front of the judge? So procedurally, I'm going to leave it to the discretion of the court with the idea that we could be back, even if it's me appearing by Zoom at any point in time as soon as possible.
So, Mr. Sheffalo, I did get a message from Judge Cooney's court recorder. They are in court today. And because they don't have prelims running, we could ask the jail when you're finished here with the next case, if they could Zoom in with Judge Cooney, if that would work with your schedule this morning.
We would try to make it work. I understood that the underlying judge was Judge Stepka, so I don't know if Judge Cooney would, if Judge Cooney was her official judge, or if he would just be taking a plea, but then delaying the sentence disposition process for Judge Stepka.
So this is a Judge Cooney case. Oh, you are right. It is a Judge Stepka case, but he is not available. But Judge Cooney is, if you're comfortable with that.
I'm comfortable with that, but I'm not sure that the judge would. I don't want to speak for the court, but I'm not sure that Judge Cooney would ultimately do the sentence. So I think I'd be in the same position. The plea would be done certainly, but then it would just be, we'd be waiting for Judge Stepka for the disposition. And I think we might be able to do the plea and disposition with Judge Stepka all at once would be my thought.
Let me verify. Jerry, do you know, is this a Judge Cooney case?
It should be a Stalker because it's even.
Let's see.
Well, it depends on who she took up a plea before.
Right. I don't know who originally took the plea. We don't have access to our system right now, but
my records indicated as a Judge Stepka case as well.
Okay. All right. So with that being said, we'll ask the probation department to schedule this with Judge Stepka.
Yes, Your Honor.
And we will, at this point, I am going to keep you remanded, but we will get that expedited. So I'm not sure what, let's see. So we'll leave it at that. We'll keep you remanded right now, but ask the probation department to schedule this for a plea and sentencing via Zoom with Judge Stepka.
Thank you, Your Honor.
You're welcome. Right. Okay. So do you have any questions right now, Ms. President?
No, Your Honor.
Okay. Very good. Thank you so much. And we'll get some paperwork sent over to you. And hopefully we'll be able to get a line on how soon we can get that scheduled.
Thank you, Your Honor.
All right. Thank you.
In the Wexford County Jail, is that Kyle Cronin?
Yes, sir. Good morning, Your Honor.
Good morning. The court is on the record in the matter of People versus Kyle Richard Cronin. This is file 24-4931 FC.
Ryan Ziegler on behalf of the people, Your Honor.
Thank you. And sir, you are Kyle Richard Cronin, is that right?
Yes, Your Honor.
Welcome back, Mr. Cronin. As you know, I've got to go through some waivers because you're here without counsel. Is it your knowing and intentional request to be here today without the benefit of an attorney?
Yes, Your Honor.
And you are making that choice clearly and unambiguously, is that right?
Yes, Your Honor.
And you're making the choice to represent yourself, knowing that there are risks involved, correct?
Yes, Your Honor.
And do you understand clearly the maximum penalties that you're facing for each of the charges you're facing?
Yes, Your Honor.
Do you want me to go over any of those things in more detail, or are you satisfied that you understand the penalties you're facing?
I'm satisfied, Your Honor.
All right, and you're still asking me to allow you to represent yourself, is that right?
Yes, Your Honor.
All right, so we're here, Mr. Cronin. I'll continue to permit you to represent yourself for all of the reasons I've said previously, and because it still appears clear to me that you're making a knowing and intentional decision to waive the assistance of counsel. If you change your mind in any way in the future or need to talk with an attorney, let me know and I'll make that happen. Mr. Cronin, we're here for two different things today. One is we're here for a status conference. Secondarily, we're here because you filed a motion. I want to clarify a couple of things for you. It might not matter because I know that when we discussed the case last month, I gave you and the prosecutor about 30 days to file any motions. That time has now come and passed. But to the extent any motion is filed again in the future, what you need to do, Mr. Cronin, is contact my staff to get a hearing date. I know that can be confusing. I have time on the docket today that I'm going to cover the motion. Sometimes I don't have that time though. And so the reason it's important for you to contact my staff is to set aside specific time for a hearing. So if you need to file any motions in the future, I would not guess that you would need to since the motion cutoff has come. But if you do, you need to secure a hearing date. Make sure my staff sets aside specific time for the hearing. But again, I understand that you're not an attorney, and so that process is probably somewhat confusing. In any event, I've had a chance to review your motion in its entirety. I've also had a chance to review the prosecutor's response to the motion. In terms of the background, the court exercises discretion under MCR 2.119E3, and I'm going to dispense with oral argument. In other words, I'm not going to benefit from oral argument, and so I find that it's unnecessary. Again, I've had a chance to review the totality of the motion. The motion cites several different things, Mr. Cronin. It states similar things to what you claimed in your previous motion. In other words, you first start by claiming that various statements given by the alleged witnesses were substantially inconsistent, and that the victim then messaged or indicated a text message that there was a claim of that you were sleeping with his girlfriend. You object to that statement as hearsay, but the court would note that from what I can tell, the statement, whether or not you were sleeping with the victim's girlfriend or not, is not being offered for the truth. In other words, it's not being offered to show that you did in fact sleep with someone. It's being offered to demonstrate what happened and why it happened. Under hearsay rules, as you correctly articulated, hearsay is a statement that's offered in evidence to prove the truth of the matter asserted. But as the prosecutor indicates in his written response, the truth of that allegation is meaningless to the prosecution's proofs. In other words, convicting you or proving to the jury that you actually did sleep with an individual is really not the point. The point is, and the only point is, it gives context to how this alleged altercation arose. Because the statement's not offered for the truth, it's non-hearsay by definition. It shows the effect on the listener. It's not being offered for the truth. If you want a limiting instruction, that is for me to read an instruction to the jury that they can't consider evidence that you slept with another individual or claims that you slept with another individual as negative and draw a negative inference against you because of that, I would be willing to read that as an instruction to the jury. Because the jury will know the only things that they can consider is whether or not the prosecutor has proven each of the elements of the crimes beyond a reasonable doubt. They can't, for example, convict you because they think you're a bad person because you slept with another individual. But again, the prosecutor's not offering the evidence for the truth of the matter asserted that you did sleep with the individual, only to show context and what the effect on the listener was. It's a state of mind exception, as well as showing intent, plan, or motive. For those same reasons, the prosecutor's offer of proof under MRE 404B is found convincing by the court. I have to go through various analysis when I determine whether or not a prosecutor can offer what's called other bad acts. First, I question whether or not any evidence that pertains to this allegation, whether or not you slept with another individual, is even another bad act. It's not been insinuated to me that there's any charge of criminal sexual conduct. It doesn't appear that there is. And simply sleeping with another individual is not necessarily a crime or a wrong or an act. It is an act And because, again, there was at least some sense that it could be claimed that it's wrong if, in fact, Mr. had a girlfriend that you slept with, again, it still falls within that other crimes, wrongs, or acts broad category of 404B. So first I have to find that the prosecutor offers the other bad act, if it is a bad act, for a proper purpose. Again, I've already noted in addressing the hearsay objection, the information is being offered to show a totality of events. What happened? What was the context of the altercation? And how did it arise? It's being offered, therefore, to show state of mind or intent, plan, or motive. Those things are acceptable under 404B, and I find that the prosecutors offered those things, the other bad act that's alleged, for a proper purpose. It's also clearly relevant because it shows the reasoning for the background. In other words, without the evidence of why the altercation arose, the jury would not have a full picture of what happened and why it happened, at least according to the prosecution's proofs, which you'll be able to question and cross-examine. So it's being offered for a proper purpose. I don't find that the bad act itself is otherwise problematic under 403, because while it might have some prejudice to you, in other words, a jury would hear that allegedly you slept with a girlfriend of the alleged victim, that is marginally damaging to you. Again, there's no crime that's been alleged. It's simply an allegation that you slept with an individual, which is not salacious, and it's not really damaging in any way. But the probative value of the evidence is significantly high because, again, it shows context, it shows the reasoning for your involvement with Mr. Siebold, if you had any involvement with him at all, and it shows basically the entire picture. So even if there is some prejudice, the prejudice is outweighed significantly by probative value. And in order to bar that testimony or evidence under 404B, I would have to make the finding that the probative value is substantially outweighed by the danger of unfair prejudice. Again, there's very little prejudice at all. It's not unfair. It just simply paints the entire picture for the jury. And so ultimately I can and will read a limiting instruction. That's what the case law allows. Meaning if you want me to read an instruction to the jury again, that they can't consider negatively the fact that you allegedly had, you slept with this other individual, I would read that as a limiting instruction. And because this is the prosecutor's 404B motion, I'm actually going to ask the prosecutor to craft a limiting instruction that says you've heard other evidence, which indicates 4 other bad acts, including alleged sleeping with another individual for which the defendant is not on trial. And you cannot consider that evidence as evidence that Mr. Cronin is a bad person or that he's likely to have committed the crime, but you can consider it in deciding whether or why the event happened, if the event happened, and so forth. Can you attempt to craft a limiting instruction, Mr. Ziegler?
I'll do that, Your Honor.
All right, thank you. And so when I go further into the motion, there's also claims that there is violations of the Brady rule and exculpatory evidence. I don't find those claims to have merit. And the reason I don't is exculpatory evidence has a specific legal meaning under Michigan law. Exculpatory evidence is evidence which reasonably leads to a belief or proof that the defendant is not guilty. The evidence that you're claiming is exculpatory, Mr. Cronin, is that the witnesses in some way, shape, or form all possess firearms illegally. That either is the case or it's not, but it has nothing to do with whether or not you are guilty of the crimes you've been charged with. So it's not relevant to the charges. It is evidence that needs to be turned over to you, and it was, meaning you need to and have a right to have information about all of the witnesses. But it's not exculpatory. The fact that one of the witnesses may have possessed a weapon when they were not legally able to do so does not shed any dispositive light on whether or not you committed the offenses of which you're charged. And so it's evidence, but it's not particularly relevant, meaning I'm not even convinced at this point that it would matter that the jury would be entitled to hear whether or not one of the witnesses or all of the witnesses possessed firearms illegally, because it's not responsive to the question of whether or not the prosecutor can prove your guilt or the offenses that you're charged with. Again, from a bottom line baseline of relevance, I'm not convinced that whether or not those other witnesses possessed firearms is even relevant to the charges that you've been charged with. But certainly that evidence is not exculpatory to you either, because again, whether or not those witnesses possessed a firearm illegally, the prosecutor still must prove what you did and whether you did it with the intent that he claims you did. So I don't find that that's exculpatory evidence, and therefore I don't find that there's any Brady violation. Similarly, you can't simply say that there's been a due process of law violation and then use that as its own sword. You have to show to me, you have to demonstrate that there's been a due process violation. I don't find any due process violation. You haven't really articulated for me what it is. You claim prosecutorial missteps or prosecutorial problems. in filing the motion, and that's been done in bad faith, the motion under 404B. I don't find those things to be supported. I simply note that the prosecutor had a duty to file a 404B motion if he wanted to bring in other bad acts. He did so appropriately. And the purpose of the notice and the requirement that I required that he file within 30 days of last month is to provide you pretrial notice well in advance of the trial so that you can be prepared to meet the evidence. That's the general basis of any due process requirement, is opportunity to be heard. You have had that opportunity. I've heard you, I've heard your claims, but I don't find that any of those claims individually or in totality merit any relief. You also have indicated, again, Brady violations. I don't find those to be clear. You've also made separate claims that really don't have much meat on the bone, that there's affidavits that don't have complaining witness signatures. That is not to the court important at all, because the court file would either contain the signatures or it doesn't. The fact that you don't have signatures on discovery copies for you has not been shown to me to be problematic. You've not claimed that it is other than saying it is, and you've not cited any case law that says that you somehow have a right to a dismissal of a case because copies of your discovery materials don't have original signatures on them. No case has been cited, no statute has been cited. That's an abandoned argument to the court. So while I understand your concerns, Mr. Cronin, none of them merit the relief that you're asking for, which is dismissal. Again, you will have a full opportunity at trial to present your version of the events, to bring in relevant evidence, and to challenge the prosecutor's evidence. Ultimately, then the jury will have to decide whether or not they believe the evidence that's been presented and whether or not they believe that the prosecutor can prove this case beyond a reasonable doubt. But while you brought all of these different motions and requests, I don't find ultimately that any of them are convincing in the manner that you seek, which is dismissal of the case. And so ultimately the motion to request dismissal, whether it's under a civil rule 2.116 C8, C10, C9, or otherwise, is denied. I'll just need you to prepare an order, Mr. Ziegler, that says for all of the reasons stated on the record, the defendant's motion to dismiss is denied. Can you prepare that?
Yes, Your Honor.
So that leaves us with a status conference, Mr. Cronin. A status conference normally is where I would hear from the attorneys and decide what I need to do. Do I need to set this case for trial? Do I need to give you some more time to discuss with the prosecutor, or how else should I be proceeding? So I'm gonna hear from the prosecutor first, then I'll hear from you, Mr. Cronin, and then I'll decide how we need to proceed. Mr. Ziegler, for status conference purposes, how do you think the court should be proceeding today?
Your Honor, I've had 2 Zoom meetings with Mr. Cronin over the course of this case, one just prior to the preliminary exam and one during the last 30 days. During those meetings, I've attempted to engage in plea negotiations with Mr. Cronin. Mr. Cronin has advised me that he's not interested in taking a plea or discussing any potential plea offers. So I would just ask the court to docket it for trial.
All right, is that accurate, Mr. Cronin? You would prefer to have a trial in this case as opposed to discussing plea options?
Yes, Your Honor.
All right, so let's talk about the trial dates then, or scheduling purposes. I want to look at the information more specifically and how many witnesses you have listed. It looks like you have 5 witnesses listed on your information. This is a 5-count case. How many days do you think you'll need to put on the people's proofs, Mr. Ziegler?
Your Honor, I believe we could get it done in 2 days.
All right, so outside of Trooper Allward, James Kotowski, Detective Sergeant Brett Nichols, Christopher Kotowski, and Jamie Siebel, do you have any other additional witnesses that you may call?
At this time, Your Honor, I don't believe I would be naming any other witnesses.
Mr. Cronin, are you intending on calling witnesses or testifying yourself? Do you know yet?
No, Your Honor.
All right, no as to calling witnesses and to providing testimony, or you haven't made that choice yet?
That is correct, Your Honor. No on both counts.
Okay, so if I had the 5 witnesses called, if I set aside 2 days, do you have any reason to oppose a 2-day trial being set, Mr. Cronin?
No, Your Honor.
All right, and so I want to go through a little bit of the background. I'll set a 2-day trial. Mr. Cronin, I'm guessing you want me to set this trial as soon as I can. Is that right?
That's correct, Your Honor.
And you're asking for a trial by jury, correct?
Yes, Your Honor.
All right, and do you have any opposition to the court simply setting this as soon as my schedule will permit?
No, Your Honor, I would just amend my previous statement slightly. There may be 1 or 2 additional witnesses to establish foundation for exhibits, particularly videos. I know we called Mr. Neil Way at the preliminary exam. I would probably call him again. It might be 1 or 2 more short witnesses.
It still can get done in 2 days?
I believe so, yes.
All right, so we'll get a 2-day jury trial set. Mr. Cronin, I want to go through some procedural things with you. Because again, I know that you're representing yourself and I want to make sure you have at least some idea of what to expect at a jury trial. All jury trials start with what we call voir dire. Voir dire is where you get to ask questions of the jurors and the prosecutor does. The purpose of the questions and the allowability of the questions is focused on whether or not those jurors can be fair. So questions about their background, what they do for a living, whether or not they believe that all people that are charged with crimes must be guilty, things of that nature are always permissible. As long as you're asking questions of the jurors about whether they can be a fair juror, I'll permit you to ask any of those questions. Same thing with the prosecutor. I generally don't interfere with the method or the scope of voir dire, but bear in mind, the questions can only relate to whether or not they can be fair jurors. I can't think of something that would be problematic, but there are things that are problematic if you're asking jurors. So just be aware of the fact that the questions all have to relate to whether or not those persons can serve as fair jurors in the trial. Do you have any questions about voir dire or what that means, Mr. Cronin?
No, Your Honor.
You have an absolute right to appear in trial free of any shackles and free of the jail oranges that you have on now. Do you have clothing for trial?
No, Your Honor.
How are you going to arrange for clothing for trial?
At this time, I'm uncertain.
Well, and I understand that you're uncertain. You may not have even thought of it yet, but I'm not going to allow you to proceed while you're in jail oranges. That would be problematic for many reasons. Right. So it would signify that you are guilty before you have even had a chance to defend yourself. So if I set the trial and set it out at least 30 to 60 days, do you think that'll give you time to make arrangements through the jail to get a suit or a dress shirt and a pair of slacks, something like that?
I can attempt to ascertain some sort of suit or something for the trial.
Let me put it this way, Mr. Cronin. The court is willing to assist if you need assistance, but I'm going to leave it to you to try and get those things in order first. If you're not able to get those things in order through the jail and make sure they understand, my order is that you're going to have alternative clothing. You're not going to be in trial in jail oranges. That would not be fair. So if you can't get those things done on your own because you're in jail, you need to file a motion in writing and let the court know. And then I'll have court staff assist with getting you clothing and making sure that you're dressed appropriately for your trial. Do you have any questions about my suggestion in that regard, Mr. Cronin?
Who would I send a request to? Would that be your assistant or you yourself?
Well, first, you're going to need to contact the jail administrator there in Wexford County and just tell them what your concern is. You've got a jury trial that's going to be upcoming. You need to have clothing suitable for trial. If they're unable to assist you with that, and Kalkaska County can't assist you with that, then you can send a motion, file a written motion, a written request, and I'll work out a way to get you clothing. I don't know how that's going to work yet, but I'll make it work so that you don't have to be in jail clothing during your trial.
Okay.
Do you have any other questions about what trial will look like or anything else, Mr. Cronin?
No, Your Honor. As to the trial, Your Honor, if there's a chance that I can file another motion in between now and the trial date, and I contact your assistant, would I be able to file that motion and be heard on it?
What type of a motion?
Similar to what I attempted to file before. I'm still in a learning curve right here. I'm trying to ascertain a dismissal of this case because I'm innocent of the charges. I just am uncertain of the way that I need to convey that to you to where it's proper and follows all the procedural.
So, Mr. Cronin, I'm not going to bar you from filing an additional motion. If you file multiple additional motions that say the same things, I ultimately likely will bar them. Because ultimately, I think what it comes down to and what the facts of the case show so far it comes down to is whether or not the witnesses on behalf of the people are believed or whether or not they're not. But that's a credibility issue. And credibility is always an issue for trial. And so it's not an issue that's capable of having me decide pre-trial. It's one where if a prosecutor's witnesses claim A, B, or C, the prosecutor will have to prove A, B, or C. But I, as a trial judge, don't have the ability to dismiss charges based upon credibility concerns. So I'm not going to stop you from filing a motion, but ultimately, if it's a factual issue, the jury needs to resolve it. So if you have another motion, you can file it. I'll address it. If there's another request that's similar, again, I'll have a hearing. I'll make findings on it. I'm not going to bar you from doing that, particularly because you're in pro per, at least not yet. Again, if it gets repetitive to where you're filing the same things over and over again, I might ultimately bar those things. I'm not inclined to do so yet. Mr. Ziegler, I know I set a 30-day cutoff for motions and notices. Did you wish to be heard on the court's impressions so far?
Your Honor, only insofar as if the defendant has the ability to petition the court for additional things for a period of time. We may need to also petition the court depending on what's in those filings.
All right, and so I'll take note of that as well. Again, I'm not really making an exception to the motion cutoff, but I am telling you this, Mr. Cronin, if you have an additional motion that you want to re-articulate what you're asking for, you can do it. I'm also going to let the prosecutor respond to it. And if the prosecutor has additional motions in light of what you filed, then I'm likely to let him be heard as well. But those things need to be filed quickly because I'm going to get this trial set very soon. You have a right to have a quick trial, and so do the people. And so I'm going to get this trial on my docket very soon. If you have motions that need to be resolved, you need to get them filed so that I can resolve them prior to trial. Do you have any other questions, Mr. Cronin?
No, Your Honor.
Anything further for today, Mr. Ziegler?
No, Your Honor.
All right, we'll get the trial date set, get your motions filed if they need to be filed, Mr. Cronin, and we'll see you at your trial. Again, make sure and get those arrangements made very soon for clothing or file a motion asking you to assist in that regard, okay?
Okay, thank you, Your Honor.
Thank you.
Thank you.
Need to appear in person or via Zoom?
Yes.
And are you still comfortable proceeding to sentencing via the Zoom proceeding?
Yes.
Mr. Seeger, are you also satisfied to proceed via Zoom?
No objections, fine.
All right, and Ms. Clark, did you have enough time to go over the probation violation report with your attorney?
Yes.
Any more time to do so?
Yes. No, I don't need more time. Sorry.
Okay, Mr. Seeger, on behalf of the defense, do you have any corrections, additions, or deletions to the PV report?
No, Your Honor.
You believe the guidelines that were and are accurately stored?
Yes, sir.
On behalf of the, I'm going to cover this with both attorneys, so I'll just start with the defense. Is there any update to the sentence credit? I know that we talked about whether or not there was going to be changes and whether or not she was under sentence in Otsego County or not. Do you know what dates to the sentence credit of 46 days, Mr. Seeger?
I believe that's correct, Your Honor, because she was under sentence, and so theoretically she wasn't receiving credit. The court had indicated that it would, I don't know how best to say it, it would take it into account or consider it to be fictive credit.
Well, so has she been under sentence since they?
She has
May
been,
8th
Your
in
Honor, and I
Otsego?
believe she doesn't get out until November, I think.
Okay, so about three months total that she doesn't get credit because she's under sentence, but that you think I should take into account. And I told you I'll take into account.
Yes.
Does that sound accurate to you, Mr.
It
Seeger?
does.
All right, then, do people have any corrections, additions, or deletions?
No, Your Honor.
And do you believe the guidelines were and are accurately stored?
Thank you.
Your allocution on behalf of the people.
Your Honor, the guidelines initially in this case were 10 to 23. This is a circumstance where Ms. Clark was sent to attempt to complete a drug treatment court program. I strongly support drug treatment court programs because they provide a carrot and stick type approach to helping people get clean and get over their addictions. The carrot, of course, is that if they successfully complete, at least in our county, a treatment court program, their sentence can be reduced. And in any event, whether there's a plea benefit or not, it's certainly to their benefit to go through the treatment, to attend all the counseling and the classes, and to get clean. That benefits both them and the community. Along with that, and in my mind, correctly along with that, there's a stick, which is that if they fail to complete the program and they don't take the program seriously, that there's a detriment to them at the end of it, which is namely that they're subject to being sentenced to the underlying offense. And in this case, the underlying offense was quite significant. It was a possession of methamphetamine. The guidelines were 10 to 23. I think she should have to bear the consequences of her actions, especially whereas here she did not only did she not successfully complete, but the report indicates there were numerous violations in the program. And it looks like it was all in a very short time frame between September of 23 maybe March of 24, some positive testing, some failures to appear. Those are significant violations of the drug court treatment program. So in my mind, Your Honor, a sentence needs to be imposed to impress both on Ms. Clark and to the community at large, that when you get the benefit of a treatment court program like Ms. Clark did, that you need to take that opportunity seriously or there will be consequences for that. That being said, Your Honor, the court has already indicated, number one, that there is some credit
And also that the court is going to take into account the fact that there's been about 3 months since when we started these proceedings and when we arrived here, where she's essentially been incarcerated without credit. Your Honor, I would ask the court to impose 12 months of incarceration. I think that's an appropriate sanction for her conduct in this case. It's at the lower end of her initial guidelines range. And I think it adequately takes into account the fact that she's been under sentence for a period of time, so that we're not seeking any higher term of incarceration in terms of prison, which the court could do under those guidelines. So I think a 12-month sentence with the 46 days credit that she's entitled to is appropriate. And I think that takes into account the fact that because the court could easily justify sending her to MDOC for a period of up to 23 months. Thank you.
Thank you. Mr. Seeger, on behalf of Ms. Clark.
Ms. Clark, and just to verify, is your earliest release date somewhere in or around November? Is that what you told me?
Yes.
And Your Honor, I guess from my perspective, and I appreciate that Mr. Ziegler was complimentary and allowed her to get into drug treatment, because I think that that's helpful to anyone to get into programs like recovery court or sobriety court or similar-like programs. And clearly the state and our legislature has thought better of it, creating those courts and those specialty courts to allow people to address underlying substance abuse problems, which clearly Ms. Clark has pretty significant substance abuse problems. I don't find it strange or unusual, Your Honor, for people that have relapses or struggle with their addiction, even when they're in the court. It's always somewhat ironic to me that courts are sometimes, or prosecuting attorneys are sometimes, will point out, well, this person continued to have problems with their addictions. Well, they've had addictions for long periods of time. It's on paper, or just because somebody tells you something, or just because you're receiving information relative to substance abuse problems, doesn't mean that you're going to immediately be able to cure it. And I think that people maintain periods of sobriety for a period of time, and then they struggle some more, and then instead of using maybe some coping mechanisms that they utilized or learned through the course of the recovery, they fall back and they just resort to what was comfortable to them at one point in time, not maybe particularly understanding that that's the whole reason why you're in the predicament that you're currently in. Be that as it may, Your Honor, if she's not getting out until November, what I was hopeful the court would do would be to not impose a sentence that would affect her potential out date in that Sago. Primarily, Your Honor, one, it has to do with where she would serve her sentence. To the extent that the court followed the recommendation of the prosecuting attorney, it's possible that she would be returned to the Kilkasket County Jail, at which point she would be sent to the Wexford County Jail, at which point Kilkasket County would have to absorb the cost of housing her in Wexford County. I know that's not a primary concern of the court, but that's a practical problem. She's already serving time in, I'd say go for a similar like item, wherein again, she struggled with maintaining her sobriety. I would much prefer her the opportunity to get into treatment following. I'm not sure exactly what's going to happen there, but once she's released, for her to go forward and get into treatment, that's something that she can address. Even if she had failures before, it certainly would be beneficial to her going forward. In this particular case, Your Honor, the guidelines call for a range of 10 to 23 months. I agree that the court could send her to prison. I just find it unlikely that the court would send her to prison, given that this was not a case of delivery or manufacture. This is merely a case of somebody being involved with a substance for which they had an addiction. No one was hurt. She wasn't selling drugs. This was merely a case of her possessing something that she clearly shouldn't have possessed. So this is a case of malum and prohibitum as opposed to malum and se. The court has generally directed people to get into treatment when that was available to them. I do again recognize that Ms. Clark was given an opportunity, and it was somewhat of a special opportunity, because in Kilkasket County, we don't have a recovery court like Otsego does, and it's not often that the court is in a position to sentence someone into that court. But it appears as though Judge Cooper had addressed it at one point in time, giving her various censures, sentencing them to a certain time here and there. So I think that it's very well understood what she needs to do going forward. The only thing that I can ask the court to do is to give her the de minimis sentence. I'm hopeful that the court will take into consideration the time that she spent theoretically, all sentences must run concurrent unless there's some statutory reason why they should not. In this particular case, I think that everything would have run concurrent, but she wasn't receiving credit primarily because of an error that the attorneys had made relative to whether or not it was a technical or non-technical violation, at which point the matter was argued, or determined that a different sentence should be imposed. But I think that this has been a learning lesson for Ms. Clark. She wants to get back to her family. She wants to attempt to stabilize her life. I would just prefer, I guess it's not a question of preference, but it would seem to me to make sense that if she was not going to get out until sometime in November, that would be that there would be September, October, November. There would be at least an additional 3 months if the court was giving her somewhat fictive, for lack of a better phrasing, credit for an additional 3 months. That would be 6 months plus the 46, I think it was 46 days, Your Honor, that she had served, which would be close to 10 months, less the good time that she may be entitled to, which I'm not entirely sure, Your Honor, on the sentence, how that would work specifically. But I guess, Your Honor, just from a practical standpoint, I would much rather serve out her sentence in Otsego and then not return to Chilkaska County. She can get whatever resources she needs from there. She can continue her treatment there. She can do other things there, but we should probably just close our file here completely, which is what probation was asking for. I don't see the need for, and this may be a case, it's not that you generally get a benefit for picking up a new file or anything, but where a downward departure might be appropriate, in as much as at one point in time, the court did believe that an appropriate sentence, albeit that was based on law, not necessarily on what the court thought was appropriate, thought that 15 days was an appropriate sentence based on what had allegedly happened during the course of her probation. She was discharged. It's just that we come back now based on the error of law. She's being resentenced. So I would just ask the court to give her a similar sentence to the one that she's currently serving, not to outlast her sentence in Otsego, so that she wouldn't have to return. Presumably, Your Honor, if the court gave her a greater sentence than she's serving in Otsego, she has to return here and spend her time here as opposed to Otsego. She's already been housed there.
Thank you. Ms. Clark, was there anything additional that you wanted to have the court hear before I impose sentence today?
I just want to say that once I do get out from wherever that is, I do have a stable place to live. I still have one of my jobs. I plan on continuing my treatment and my individual counseling. And I'll also be working with the Adult Learning Center over here, start my college classes, which I've been trying to do for 10 years. And they finally made it to where I can do it. So I'm really excited about that.
Well, thank you, Ms. Clark. I'm glad to hear that you have a positive outlook. You sound and appear well. Much different than I recall you appearing at the time that you originally were discharged from drug court. Obviously, you were in active addiction and you had difficulties completing that program. But I'm glad to hear that you've got good plans for working and stable residency, plans for counseling to continue, because all of those things are going to be necessary if you want to stay out of the Otsego County, Chilkaska County, or whatever other jails in northern Michigan or wherever you reside. This case in some ways is unique and in some ways it's not. It's unique really only because the court made an error of law. When I sentenced you to 15 days originally, it's because I misinterpreted the statute and I misinterpreted what my discretion was or could be. I gave you 15 days in jail because that was my interpretation of the maximum that I could. Not because I said I think it was a fair sentence, but because I thought I was limited because it was a technical violation. But again, for the reasons I've already indicated, that wasn't accurate. And as the prosecutor pointed out, the duty of the court is to impose sentence if you don't complete a drug treatment court. I have to sentence you on the underlying file, not as a technical probation violation. In this case, the difference is when I originally sentenced you, I held all jail in abeyance, 10 months, the minimum of the guidelines, held it in abeyance, and told you that if you successfully complete drug court, you wouldn't serve any of it, but if you didn't, that you'd likely serve all of it. That reasoning still makes sense to me, minus the correction because of my error of law. Meaning for the last 3 months, you've been sitting at dead time because you're under sentence in Otsego County. So while ordinarily, when I've already imposed the sentence but held it in abeyance, I would simply just impose it. I'm not going to do exactly that today. Instead, I'm going to take into account the 3 months that you've been sitting because of my error of law, and I'm ultimately going to sentence you to 7 months in the Otsego County Jail, in the Kalkaska County Jail. You have credit for 46 days that you previously served. I'm not necessarily concerned with how that lines up. If it means that you get to serve all of your time in Otsego, that's fine. If it means you have to be transferred to Kalkaska or any other county, that's fine too. The time that I'm imposing is time that I already imposed minus the time that was a mistake by me. And so I think that's a fair sentence because I told you what it was going to be before you got the potential benefit. You didn't ultimately get that benefit, but you've got a good plan in place going forward. So the court's order will be 7 months in jail, credit for 46 days served. All probation costs and probation oversight fees still remain in place, although I am terminating you unsuccessfully for probation. In other words, you still have to pay all the fines and costs that I imposed previously. No new additional costs are imposed. You have the ability to ask the Court of Appeals for a leave to appeal. We'll have those appeal rights sent to you, care of the Otsego County Jail. You'll need to sign the top copy to indicate that you've gotten a copy, and then you sign the bottom 2 copies if you wish to ask for a leave to appeal. Do you have any questions regarding any of that, Ms. Clark?
No.
All right, good luck then on your recovery. Mr. Seeger, anything further?
No, sir.
Mr. Ziegler, anything further? There you go. All right, thank you, Ms. Clark.